Welcome to the Pasadena Bar Association. I am a proud member of this great bar association, and this is our first Zoominar, as Judge Mary House has named this today. I am happy to announce that we have 243 people that have RSVP'd for today. It might be one of the biggest bar events that we've had here in Pasadena in quite a while, and I have a feeling we're going to see a lot more. Today's topic is mediating and litigating during the pandemic. And I'm going to say that it's also probably going to be very relevant to when the pandemic is over with, and we'll get into that. First of all, I want to recognize our great president, Brandon Carroll, and of course, Michelle Paniagua, our executive director, who coordinated this with us and allowed us to take the stage and present to you today. We are in a new world, for better or worse. I don't know about you, but I've been really devoting my extra time to eating extra, gaining some weight, growing my hair long, and I've even taken up to smoking cigars. So, hopefully you're doing better than I am right now. And but either way, here we are. We're getting back in the saddle, and we're going to talk about some important things today. Videos are becoming more and more popular, obviously, because of this situation that we're in. And I personally believe that today's lesson is going to go far-reaching, that it's creating a different type of a system for us, and it's exciting to think about that. For me, the thought of not having to travel all the way across the world in order to attend a deposition or to do mediation is going to be pretty good. So we got two experts with us today. And first of all, let me introduce our sponsor who's hosting this today, and that's Alternative Resolution Centers. ARC has been a sponsor, an official sponsor of the Pasadena Bar Association for about 8-9 years. And they've been with us all along. And with us today, we have Nicole Bethram, who's our case manager and marketing director of ARC. How are you, Nicole?
I am well, thank you. We're excited to do this presentation today and be part of it.
Absolutely. And you'll be hanging on just in case we stumble along the way to help us out here.
Absolutely.
We have, of course, somebody that we had to bring in, and that is Judge Mary Thornton House. How are you, Judge?
I'm great. I'm thrilled to be here and to be part of the bar. I always have been.
Well, we miss you. So for all of us Pasadena Bar Associations, Judge House is a permanent fixture of our association. When she was the supervising judge of Pasadena, she participated and led many of our events. For those of you who aren't as familiar with Judge House, she recently retired after 22 years on the Superior Court, where she presided over countless jury and court trials in civil and probate departments. I actually had the pleasure of doing a trial in front of you. I got to tell you, that was one of the best trials I've ever had.
Oh, thank you.
Even though you put me through the ringer with the evidence code. Okay. With experience serving as the supervising judge of the Northeast and North Central districts, hub operations, and assistant supervising judge of civil countywide. Now, her resume goes on, but I don't want to take too much time because she's got a lot of good things to say. Our second expert and mediator with ARC is Sid Kanazawa. And I know I just butchered your name. How do you pronounce your last name, sir?
You said it perfectly, Kanazawa. It's a good Italian name, Kanazawa.
Okay, so Sid is a mediator, arbitrator, trial lawyer, and bridge builder, bringing people together even when it seems impossible. This is very important. For over 40 years, he represented plaintiffs and defendants locally, nationally, and internationally in jury and non-jury trials, arbitrations, administrative proceedings, crisis, mediations, and negotiations. And in preparation for today's Zoominar, I got to know Sid, and I can tell you that he's one heck of an experienced trial attorney, and he's as passionate about mediating as he is about all aspects of the legal profession. So I don't want to waste a lot of time with this long wind up. Why don't we turn it over to you, Judge House? And Judge House is going to talk about two things. First of all, she's going to give us a little brief talk about the state of the court, because since she's recently retired, she still has an ear as to what's going on. And I know a lot of you out there want to know what's going on. It's our livelihood after all. And then she's going to get into the seminar and give us some really good tips about what we have to do with regard to mediation, arbitration, whether or not we need we could use ARC for refereeing through Zoominar, and some of the other features that Zoominar provides to us as we're doing our work. So Judge House, having said that, it's all yours.
Oh, great. Thank you. Thank you, Don. That was a lovely introduction for both Ark and Sydney. I guess myself, okay, but thank you. First of all, I think many of you know me and know that I've been a real devotee of remote, not having to be in the courtroom. I've pushed court call for probably 15 years. And I've even used videos, conferencing to have witnesses come in and testify. One of my last trials on the court is we used the court call video, live video conferencing to get a witness in from Tennessee, and it was very, very effective. So I think it's really important that everyone, whether you're a techie or a Luddite, focus on using this new technology. And I say that because things are not going to be very good for a while. Once the courts start opening up, they're going to be dealing with huge backlogs in criminal. And even judges right now that are in civil are getting trained to handle criminal trials because they are anticipating that that is going to take up the bulk of the court's work. So even if you think you have a civil trial coming up or something that's going to go in the fall, I wouldn't count on it, quite frankly, in civil. And I really do believe that if they do start ramping up civil and probate and family law, it's going to be for those sort of more emergent matters, emergency matters within each discipline. For example, if you have a Code of Civil Procedure 36 priority matter, that is likely to be tried. If you have an unlawful detainer, that is likely to be of assistance once the new rules that have stopped those trials are lifted. And definitely in family law, you're talking about custody issues and those sort of things. So it's really important that all you start to embrace this technological tool of Zoom, because you can use it to at least prep and gear up for the cases that you have coming up. That's with depositions, obviously with mediations, because maybe it can get resolved. And also, I think it's important for all of you to realize that we could have a bounce in the fall and be back in the same situation we are now with limited use of the courts. Now, Los Angeles Superior Court is using, and Sydney can tell you all more about it, technology that is very effective in the juvenile dependency courts, and also they're starting to use it with video arraignments in criminal. What's interesting is a judge up in Sacramento, presiding judge Russell Hom, all of a sudden started setting up tents outside the prisons, brings in each criminal defendant for an arraignment, and he's been posting those hearings online on the court's website. So he's doing public hearings and he's getting his criminal cases taken care of. So these are going to be the tools now, and they're going to be the tools of the future. So it's very critical to embrace how you can use these, because things at this point are, basically civil is shut down in Los Angeles Superior Court, and rightfully so, because the bulk of the judges in civil are 65 and older. They're in that age group that needs to be protected. So there's gonna be a real shift in the use of this technology. So we need to embrace it. So today, the goals we really want to talk about today are how you can conduct a deposition, conduct a mediation using Zoom. We want to give you some tips, and we may be a little basic if you've been doing a lot of this technological legal work, but we're definitely going to shift into the expertise that is going to make it much more effective for you to use this tool. And we want to give you some tips. We want to also have you feel confident that this technology can assist you. I think, again, it's the wave of the future, and the future is now, and this is going to be the new normal. So, Sydney, I'd like to turn it over to you. And everyone, Sydney knows his stuff. He knows how to use this particular technological advancement, and has been using it and working on this type of thing for many, many years when he had maritime cases to handle, and a lot of his deponents or clients were on ships. So the first thing, though, before you get started, Sydney, can I ask you, why are you wearing the earbuds?
Well, before COVID-19, I had no home office in my house. Now I have three makeshift home offices for my wife and my daughter. And so we're all working in separate rooms. And so we're trying not to bother each other as we're all on conference calls and Zoom calls and things like that. So that's one of the reasons. And the other reason I'm using this type of earphone as opposed to the earbuds and things like that is because I've been conducting the mediations, and one of the problems with the earbuds is that they run out of batteries after a while. And so I have a couple, and I keep changing them as we're going through long mediations and the like. And so, just as a way of making sure nothing goes wrong, I actually use these now. And it also connects directly into my microphone, so I can hear actually what I sound like before, well, simultaneously as everybody else is hearing it. So it's sort of my own production system.
So you're a Zoom rock star recording office. Okay, I'm sorry.
So, yeah. You know, I watch all these shows of performers and all the kind of equipment that they have in their house, and I'm just amazed at you know how much goes into producing these programs and things.
Cindy, let me add something to our audience, and that is also if you are using an iPhone and you're trying to do some business over Zoom, you're going to be adding a lot of extra noise to the conversation, and it's going to get very annoying. The way to avoid that is using the earpieces like Cindy's doing as well. So sorry, but I thought I'd throw that in for those people that didn't know that. Go ahead, Sid.
That's very helpful. My experience with this video technology actually stretches back to the early 80s when there was still, and the younger people don't know about this, but there was a period of time when there was a war between the VHS tapes and beta tapes and things like that. And back in those days, there were no videographers. And so I had to buy my own equipment, and I had to construct a case that I could put everything in because it wasn't as small as it is today, you know, and just on a cell phone or anything like that. And, ship it around because, like Judge House was saying, I was doing maritime work at the time. And so the deponents would likely not be there at the time of trial. And so I've learned a lot of things about the video technology from way back then. And one of the things that's most interesting about the video technology is that you can edit it, but you're editing it with your opponent. So it's not like you're editing it by yourself. It's a real-time edit between the two of you when you ultimately present it at trial. And I published an article last week, Friday, in the Daily Journal about video trials. And one of the things that happens when you do this video technology is not only is there an efficiency in terms of being able to bring people together from different parts of the country all at once, but also there is the efficiency of presentation that you eliminate all the objections, and you can take, it's like watching the Super Bowl. I think, was it 538 estimated that most Super Bowl games are 3 hours long, or broadcast is 3 hours long, but the actual game time is 17 minutes. And that's one of the advantages of video, is that you can compress the presentation. And when I tried the maritime cases, I remember one case in which I presented 5 witnesses with cross-examination in 1 hour. And that's something that logistically would be very difficult to do in any other context. Let me share a little bit about the technology by showing you some things on the screen here. The Zoom technology, or the online mediation platform technology, one of the wonderful things about it is that it is internet-based. And as long as you have connection to an internet and you have the speed of 1.5 megabits per second, and you can test your speed by just going to speedtest.com, and you can see, how fast the upload and download speeds are for your particular unit and particular location at which you're trying to connect. One of the beauties of the online platforms is that you can connect with just about anybody, anywhere. People can connect by their computers, they can connect by their cell phones, they can connect almost in any fashion, any place that there is an internet connection. They can also connect by telephone, landlines. And just like we have conference calls today, They can connect to the same meeting by a landline, but you lose a lot when you connect by landline because you cannot see the people that are in the meeting, and you cannot know who is on the call as easily as when you can see everybody and see exactly who's listening to you and who's not listening to you. The beauty of this connection, the visual connection, is that we communicate a tremendous amount visually. There was a professor at UCLA, Albert Mehrabian, that suggested or combined a couple of studies, and there's a lot of dispute as to these percentages, but basically he was showing how much we rely on our visuals. And he was saying that the words, when we like somebody, we depend upon the words that they say only 7% of the time. We depend upon the tone in which they say those words 38% of the time. And we depend upon the visuals of what, how they're saying what they're saying 55% of it. 55% of how we get meaning is through the visuals as opposed to the tone or the words itself. The words itself, you can get it through text, you can get it through email, but you can't get the tone. And you can get the tone on a telephone call by hearing the inflection of people's voices. You know, is that your pen? Is that your pen? Is that your pen? You know, you can get a difference in terms of the intonation and where you put your emphasis in the tone in which you're speaking. But the one thing that you can't get in writing and on a telephone conference is the visuals. You can't get the visual of seeing somebody say, I agree, and know that they don't agree. Or you can't get the little hints that you can get from people's faces as to whether they're thinking or whether they're trying to deny what you're saying. No. Yes, I always, you know, or I tell the truth. I'm paying attention. You know, I'm not doing anything else. You can't see all those kinds of things without the visual connection. But with the visual connection, it gives greater meaning to the tone and to the words, because you know if it's inconsistent or consistent, and it gives a tremendous meaning. This is how we connect with each other. We are social animals. We connect with each other by mirroring. And when we really reach agreement with everybody, we tend to act in the same way. We have the same intonation. We move our bodies in the same way, and we kind of connect in this fashion. In fact, science has shown that when people are identifying with each other, feel that they're part of the same group, their brain waves are also very similar. There's an actual scientific connection between people in terms of their brain waves, their pattern of speech, a whole bunch of things that make people connect. And you can't do this just by reading a letter, reading a text, a one-way communication, as opposed to a two-way communication in a telephone call, which gives you a lot more signals and it gives you a lot more opportunities to improvise and understand the other person without offending the other person. And when you have the visuals, it's even better, because now you can see people, you can look them in the eye, so to speak, and have that kind of a connection. You can't shake their hand, you can't have a meal with them. You don't really look in their eyes because you're on a visual screen, but you kind of get the sense of it, and you can convey meaning through the image that you're creating. The other thing about the online platforms that is very useful is that you can share your screen. I am sharing my screen right now. This PowerPoint that I'm showing you is on my computer, but I'm sharing it with all of you through the screen sharing function. And there are whiteboards, and we can draw together and we can work together collaboratively in a visual format because of the features of this format. But probably the most valuable thing, in particularly the Zoom platform, is the breakout rooms. because the breakout rooms are such that you can set up a whole bunch of breakout rooms and you can put people into different rooms. And when they're in the room, they can see who's in the room. And when they speak, they are speaking only to those people in the room. And the people that are in a different room cannot hear them. And unlike a physical conference room, there's no possibility of people overhearing them in another room. Unfortunately, it can be also very isolating because you can't open the door and look down the hall and see what's going on down the hall, or see if the mediator and everybody else is still there or not. You're really by yourself. But it means that we have to be a little bit more diligent about going in and out of the rooms to make sure that everybody is in sync. But the main thing about, I think the main fear of this online platform is how we are sounding and appearing to others, because we're conveying a tremendous amount of meaning through our visual image and through the way in which we sound to other people. And so I'm going to talk a little bit about that. Let's see. First of all, let's talk about the audio. One of the things that you want to make sure when you have an audio is that the unusual thing about the Zoom situation is that you are in a separate place from everybody else. You're in a home, you're in your office, you're someplace other than the other person. So you don't have a common environment in which you're both listening to the street sounds, you're both listening to the dog barking, you're both listening to the telephone ringing or something else. You're in separate places, and so there's a possibility that one is hearing something that the other people aren't hearing. So one of the things that you want to try to maintain to create this bond between people is to eliminate distraction sounds. Anything that is external and close by, you want to eliminate that. One of the ways in which you can make your sound a little bit better is to avoid hard surfaces. You can use towels and furnitures and things like that to deaden the sound and allow the sound to not bounce so much. And in mediations, you particularly have to be conscious of who else is in the room. Because part of mediation is the confidentiality, and at a certain extent, part of deposition process may be confidentiality as well. And I think that you have to be very conscious of making sure everybody has a quiet space where they're not going to be interrupted, and where you can be assured that you're having a confidential conversation. And you got to make sure you test everything, make sure that the microphones are working and everything is appropriate. The viewing of how you appear to other people is probably the most concerning to everybody. And this is the common way in which most people appear on Zoom. They leave their laptop on their desk. They tilt the screen backwards so that it is looking up. And you can see in these views that you can see the ceiling. And I'm looking down. And in Hollywood, the videographers or the cinematographers and the people that shoot the film, they're very conscious of which angle the camera is pointing. And when it's looking up, you're trying to show a grander view or somebody looking from down up. And when you're looking down on somebody, it diminishes the character of the person. So I just wanted to show you these different views because it's dependent upon where your computer is located. If the computer is high and it's pointing down on you, you're going to get this view. And there was a CNN reporter the other day that was dressed in a suit, and he had the camera too high, and it showed his legs, that he didn't have any pants on, and he later on said that he had shorts on underneath there, but you couldn't tell, and that's the danger of where you place that camera. This is the preferred view, and this is the view that you see on newscasts. It's a shoulders to head view, and this is kind of the fairest view. And you can see in the bottom corner how I've created this view. It's by raising the computer, making the computer screen at a right angle, and I've raised the computer in order to point directly at my face. Um, but the other thing about this view that I think you should be conscious of is that this is a very, very intimate view. If you try to go and get this view, and only this view, in other words, to look at someone's shoulders and head only without seeing their body and feet, you have to be almost nose to nose with that person in order to get this view. It is a very, very close view that is not the view that we commonly have when we are in regular conversations, even before social distancing. And so as a result, even though this is the common view that we're used to seeing on television and newscasters and the like, it is actually deceptive because it is a very intimate view where you can see a lot of the movement of the face that you would not normally see in someone. You can see movements of the eyes, smirks and all kinds of things. And so you have to be very conscious that people are looking at you very, very closely.
And Sydney, wouldn't this be something a lawyer needs to advise their client of?
Yes, I think that you have to tell your client that they're always going to be on camera, and that what they're doing is going to make a big deal difference. And I think that it is something also that I've noticed in mediation is that if you have a camera that is in a conference room, there's a tendency for people to drop out, to not be connected. This offers a tremendous opportunity to connect with people on a very intimate level, and to be connected to them no matter where they are, but also connected in a very close manner so that you're looking in their eyes and you're talking to them. And there's a feeling and that's the feeling we get on television. We feel that people are in our homes because we feel that they're so close to us when we see them on TV. But I think that when people are in a conference room and they're far away from the camera, there is a tendency not to be able to connect with them because they're too far away. There's a little speck on the camera as opposed to being on the screen. So I would suggest that if you're going to do mediations and depositions, that everybody have their own screen so that you can connect with people directly. Second thing that you have to be very conscious of is where is the light source? And we're all becoming videographers and producers now that we're doing these videos at home. But when the light source is behind you, even if it's a nice looking setting behind you and all that, it tends to make your face dark. And I learned this in my very first trial using video, where I tried a maritime case, and I set up the video and I set up the witness and I was all set. And back then there was no videographer, so I did it all myself. And I took the deposition and I wasn't looking at what was being recorded in the camera. And what I didn't appreciate was that the deponent was bald and the light source for him was right above his head. So when I looked at the video later on, all you saw was his head shining and his face was pretty much black, because the video wasn't as good today as it is. And by the way, I tried to make my face black in these things, but it was very difficult because the cameras today are so good on the computers that they tend to focus in on the face, and they lighten up automatically. They lighten up the background and all that. But in this trial, I had to try that case, and it was a captain of a ship, and his head was the only thing that everybody saw because it just glowed with the light source and all that. And fortunately, his baldness became an issue as to recognition of who the captain was, and so it worked out. But nevertheless, you have to be conscious of the light source and keep that light source in front, not in back.
And actually, I think I'm providing a teachable moment. I see based on the chats that somebody thinks I have a smudge on my camera. So I'm going to work on that because we wiped it off before when we prepped this. So anyway, thanks for that observation, and I'll work on it. Something you all should work on as well. Go ahead.
So Charles, let me jump in here on that. I know we experimented a little bit before we started. I think it might be because you have a virtual background. The folks out there don't know that.
Oh, no, I thought I took that off.
I see a desk behind you that I thought was...
Yeah, that's me. That's me.
It's a true thing. Okay.
It's a true thing, yeah.
Okay.
Hey,
yeah, you have to
we're
be
all
very
learning.
conscious. Yeah, you have to be very conscious of your background, because the background, if it's close, people tend to want to see and are not paying attention to you. They're paying attention to your background. For example, here, I'm in front of a picture that has a glass or plastic frame in front of it, and it's reflecting, lights and scenes on the other side of the wall here. A lot of people have books, and Don's books are far enough back that you cannot read the titles. But if you're have a bookcase that's close by, people tend to read the titles and wonder, are you really reading those books, or did you just set that up to make you look smarter or something like that? But the
answer, Sid, is yeah, they're I've never opened a single one of those. So.
But anyway, you have to be conscious that these are the things that people are looking at, not just your face. Also, you need to think about how you're dressing and what message that sends when you're in front of the computer. How casual you want to be. Also, your posture and how you're presenting yourself also sends messages as well. And finally, I think that there's a tendency for people to do other work and look away from the screen, to put up substitutes for your visual and all that. And you wonder, what does that tell everybody else? And I think that when you don't put up, you're not live visually on the screen, I think the message that you're sending without the visual is that, I don't care enough to show you who I am, or I want to protect myself from letting you in to identify with me and connect with me in some fashion. Just some thoughts, Yana.
Great.
Well,
so I thought that what we could do is I could maybe moderate a little bit of a panel discussion here, because you both have such a wealth of experience. And starting with you, Judge House, we've delved into this a couple of weeks ago with a voluntary settlement conference. And I'm going to tell you right now that just like all other cases that I've done, I wish that there was a professional mediator there, because it felt like we were in the same room, but we had the exact same problems with personalities and things like that. So my first question to you is do you think that you could be as effective in getting people to come to terms of an agreement with a video when you're not in the room with either one of them?
I absolutely do, and I know it can be done. I've done it at the court, and I'm doing it now. And I think Sydney really pointed out the fact that there's a different kind of intimacy going on here that you don't have with face-to-face discussions. And you can use that different kind of intimacy to benefit all the parties involved, because you do have breakout rooms that you can use. You can put people aside, send them out, bring them in. So that's effective. And secondly, one of the things that we used to teach in judge school all the time is that people don't really remember too much about what you have said. They remember about what you feel. So with this intimate face-to-face technology, you're still going to get people to understand and to feel what you are saying. So I think it can be maybe not as effective as, face-to-face, where you can reach out and touch the person or let them know how you're feeling by a more personal view. But I don't know that you're limited really, because I think as we get more involved in doing this, we're going to learn how to be more effective. I mean, all the things that Sydney just pointed out in terms of how we look on screen is critical, and that can be perfected. I mean, one of the sources we gave to you in our handout is this 2006 article that Sydney provided, and that is, we all know that if Nixon hadn't sweated on TV and looked so nervous, and Kennedy looked so great, that Nixon might have been president when he first ran. And now we look at, we've had a distrust of the slickness of technology and videos and that kind of thing. And now everyone's so used to watching it that it's more effective. And I'll tell you something, I have seen jurors in court pay more attention to a videotape deposition than they did to live testimony. So I think the way the culture has evolved, that this can be an effective tool in most, if not all, cases.
Judge House, picking up where you left off with depositions, I also had the opportunity to take a deposition over Zoom. It went well. There were some technical problems. We'll field those questions to Sid in a second. But one of the difficulties I had is the camera was, of course, on the deponent. But when he was answering questions, he was looking out to somebody. And I didn't know if his attorney had a sign up and say this and, that type of a thing, hand signals. I just couldn't tell. So if you're the referee of a deposition, what are you going to do to try to correct that situation?
Well, I think we had one of the questions I see came up on the Q&A is, how can you guarantee there aren't other parties in the room standing back and giving hand signals? First of all, I think you have to have that pre-deposition conference with your opposing counsel. And I know it's kind of a pinky swear thing going on, but you've got to get something in a stipulation that says the parties agree that there would be no third persons, that if there needs to be an attorney-client conference in confidentiality, that they leave the room. Now, Sydney, you may be able to jump in on this, but you have suggested that, and one of our practice tips in our handout is that everybody have their own screen. So that may assist if the lawyer if he's on screen and the deponent's on screen, that may cut down on the issue that you've talked about, Don. But I think, at some point it's going to have to be, we're officers of the court, we're going to be honorable. And quite frankly, we've all seen in live depositions that kind of hand signaling going on. What can I say? It's just that you can't point it out on the video. But one of the things you can do with Zoom is you can get a stipulation that the deposition can be recorded. And so if it's going to be recorded, you'll know at what point there's some coaching going on, because you'll see, and you can call the person on it. Wait a minute, are you talking with your attorney? Is your attorney giving you information? Remember, you're under oath. So I think that you can try to build in some of those. I think the real issue now with the pandemic, though, is what are you going to do if they're wearing a mask? I mean, half your face is covered. I mean, not that I feel like I'm young looking anymore, because all my gray hair is coming out, and I don't know why that's happening. But anyway, I'm at the market and I'm buying some wine, and they go, you have to take your mask off. We can't tell your age. I was complimented on the one hand, but, that when I thought about it in terms of, depositions and even mediations, that could be a real issue, because you're not getting half of that reading the person is gone. So I don't know. Sydney, do you want to weigh in on that at all?
Well, definitely. I think the smile is probably the most important message that we send to other people in every culture. Right. that indicates an identity or kind of a willingness to identify with other people and all that.
Yeah, and it's not just a smile, it's a smirk, it's a frown, it's a snort. All of that's covered up by a mask.
Right, and I think that it is important, and it is a way of which we connect. In fact, the smile is so important that you can hear it in people's voice. That one of the things that I've been involved in some campaigns and things like that, and one of the things that they said was that the first thing you do is smile. And then you start talking, and it's reflected in your voice, and that's how important that action is to everything else that you do.
Hey, Sydney, I've got a follow-up question with regard to the technology that I want to ask. So we talked about the fact that people maybe need screens. So maybe you could touch on that, and then also, if you're doing a deposition, sometimes you want to surprise the other side with the exhibits that you're putting in front of them. Right? I mean, if you give them your game plan ahead of time, they've got time to think about it and they know what's coming. Is that lost in these things, or is there a way to still accomplish the surprise? So it's a compound question. Judge House, you didn't sustain any objection there. If you could kind of answer those questions, I'd appreciate it.
I'll take them one at a time. With respect to the screens, one of the amazing things about this technology is that in video depositions in particular, only the witness is on the screen. And in Zoom technology or these online platform technologies, everybody's on the screen. And so you get to see everybody at the same time, and you can detect what they're doing with respect to, sending signals or anything like that. It's the same thing in mediation. In mediation, when you're talking to people, you tend to be looking at one person. And so you may not be able to see the people that are down the table on the other side or anything like that. You can only really focus on one person. But with this technology, you can actually glance without much movement at everybody. And if somebody's moving, you can definitely pick them up and see what they're doing and things like that. And so it's very helpful to have this technology. Now, somebody asked, where do you look when you are on screen so that you look like you're looking at the people, and it's the camera. You're looking at the camera really to look straight ahead, to see, to appear to be looking at the people on the screen. With respect to new documents that you want to bring up in a deposition are really easy, exactly the way that I brought up that PowerPoint earlier. All it is sharing your screen. As long as it can be on your computer, you have it ready, you share your screen, and you can have it up. The only thing that I think that, and in some respects, it's better than in a deposition because it's recorded, and it's recorded with the deponent as they're being examined with that document. But it's also important that you appropriately number it and follow the same protocols that we have in regular depositions, so that when the written transcript comes back, you can identify the document appropriately without.
And let me put a judge plug in here. There's nothing more frustrating, and I think you always need to think of the end game, how this is going to come out in court. And for a judge, there's nothing more frustrating than someone saying, okay, this is Exhibit 7 to the deposition, Exhibit 23 in front of the court, Bates stamp number from the plaintiff, 1208, and from the defendant, 537. I mean, that is just a nightmare. As they say in My Cousin Vinny, what a freaking nightmare, all right? So if you can do, when you start the litigation, what the California Rules of Court tell you to do, and that is allot, 1 through 300 for the plaintiff, and, 400 to 700 for defendant 1, and give them numbers and have those consistent throughout the deposition, then that is going to be and that can be what it is for the trial court. You're gonna win the heart and minds of judges everywhere. And I also think, Don, yeah, you can spring documents on people, but that may be what your strategy is, but for the most part, if you share most of them that are commonly known, that will be effective, and then you spring the documents on them. But I think that gets back to my thought is, what is your end game here? I took depositions as a lawyer where I wanted to mess with them, okay? I wanted to make them angry. I wanted to see what kind of person they were, not so much what they were telling me. I don't know if that would be effective in this scenario or not. It definitely is if you videotape, and maybe that's what you should do. Secondly, in addition to the Zoom videography. But secondly, this is a really effective tool for that really mundane person most qualified, person most knowledgeable deposition, identification of documents, all of course which have to be provided ahead of time to be more effective. Take the deposition of the police officer who was on the scene at the accident. I suspect you're going to have doctors much more willing to be deposed as experts through Zoom technology than they are through having to come to an office and having to be involved, particularly those that are treating physicians, and particularly during this period of time. So I think, deposition tools are available for all types of witnesses and all types of trial strategies. And you need to start thinking about that from the very beginning. And that's true whether you're using Zoom or not. But I know many of you are worried about billable hours. You can start billing those hours on these Zoom depositions for the minor characters and, graduate to the major ones. Don, I don't know how you feel about that, but that's my thought from viewing it, post-attorney status.
Yeah, I agree. And I think that you hit some thoughts about maybe meeting and conferring prior to doing any of these, whether it's arbitration, mediation, or depositions. It seems like it's kind of essential. And the reason why I say that is in the deposition that we took, the deponent was acting like he wasn't familiar with the technology. He was acting like he couldn't hear us. And we went from the phone to the computer, and there was a problem where he supposedly couldn't see the exhibits, during screen sharing. So it seems like there has to be something. Could you speak a little bit about what you would suggest people do then prior to using Zoom for these matters?
Well, it's absolutely critical that you have some kind of pre-deposition, pre-mediation, pre-arbitration, pre-everything, just so that, and again, I'm thinking end game. You have those kind of games being played. You can write a declaration and say, we did a pre-deposition conference and all the technology worked, and he was being evasive and wouldn't answer and said he couldn't see this. I want a second deposition and let the other side pay for it. So again, I think it's critical to be able to have permission from the other side to record via Zoom the deposition, because one, I think that'll keep everybody on their best behavior. And if it doesn't, that's certainly an indication as to the problems you're having if you have discovery disputes down the line. Did that answer your question?
Yeah, it did. And Sydney, in the VSC that we did without the help of you professionals, one thing that I was quite aware of is the possibility of being accidentally on the camera talking to my client while the mic was open. I learned that I could still leave the room. I could still walk down the hall and say, I'll be back. But maybe you want to talk about how to ensure, the confidential communications are going to be, kept during these processes, especially during a deposition, I would think.
Yeah. First of all,
and
I think
mediation too. And mediation too.
And mediation, I think that first of all, you have to have some kind of an agreement regarding who's in the room, and that's where there's only so much you can do with respect to assuring that there's nobody else in the room. But that's really a critical aspect of who's in the room, who's behind the camera, and whether anybody else is listening on conversation. And again, having earphones sort of tells you something about who's listening in on this conversation. It's me and not anybody else. But that's number one. I think that secondly, with respect to communicating with other people and knowing who you're talking to, one of the things about being visual is that you can see who you're talking to, and on these online platforms. And so, since I can see, this is sort of unusual because we have a webinar, so I don't see all the audience, but I know that we are on a webinar and that I'm speaking to people that I can't see. But generally speaking, when you're in a Zoom meeting or online platform type meeting, when you're in the room, you can see who you're talking to, and those are the people that can hear what you're saying. So in other words, when you're in the waiting room, there may be other people in the waiting room that are not on your side. So you can't assume that what you say is only to one person. You can chat, and that chat can be to one person. But if you speak, you're speaking to everybody in that room.
Yeah. So going back to you, Judge Huss, I think what I would have to add to this discussion is the pre-planning is very important. If you plan on having a bunch of documents that you're going to be showing to the other side during mediation, that you want to prove, for example, that an asset exists or, the balance on an account, have those on your desktop. Be ready to
Right.
produce those. And I think, again, testing the equipment. But the downside to this, there are some downsides, is that technology could fail, or the person on the other side might be, of my generation. They don't know how to turn on, Zoom, and you're teaching them as you go along. Can you think of anything else that might be a downside to using this technology?
Well, actually, I'm kind of a Pollyanna. Let's talk about the upside. If the technology fails and you have to stop, you've not traveled to Century City or to Lancaster or anywhere, and you can reschedule it again. So I think that you can also say, maybe in the stipulation you have with counsel, that in the event of a technological failure or an inability to show documents, that you agree to a second session in which that is corrected. You can build in all kinds of protections in this mediation pre-deposition format. And I urge everyone out there to start thinking of stipulations that cover all of the contingencies we've talked about, because that way, if anyone, is reluctant later on, you have an agreement and you can enforce it. And a court will do that. So that would be my thinking. Is that an answer enough or
it's
more?
real good. It's really
Okay.
good. And Sid, can you think of any specific stipulations you would want to enter into prior to either doing mediation or a deposition? Your mic is off.
Yeah, no, I was normally in the Zoom technology that you can put yourself on mute, and if you press the space bar, you can talk, and that's one way of doing it. But I think we've turned that off with this particular program. I think the most important thing that I do in every mediation is that I put up a whiteboard and I write down my phone number, my cell phone number, and having people. Sometimes people are sensitive about me receiving their cell phone number, but I give them my cell phone number so that if they drop off the call or are somehow having transmission problems and all that, they can communicate with me. Or if I'm in a breakout room and they want to talk to me, they can communicate with me and I can come over to their breakout room to talk to them or something like that. But it does two things. One, it shows people how to use this whiteboard. And you can type out the phone number and all that. And secondly, it makes sure that everybody has the right phone number. They didn't mishear my number. They can actually hear me say it as well as see it right in front of them so that they know exactly what that number is. And I think that, yeah, there's a lot of stipulations that you could enter into. But that, to me, is the most important to ensure that you get through the technical issues that could develop in the course of the deposition or the mediation.
I have a feeling somebody from the Pasadena Bar Association has already created a great one. Maybe you want to share it with the rest of us. That's a good idea. So I think that we're kind of coming to the end of the presentation. And what I'd like to do with Judge House's permission, Nicole, if you can open this up for some questions that our audience may have of these distinguished speakers.
Put on your mic, Nicole.
Thank you.
Okay.
So we have a bunch of questions. I think we'll start with some deposition questions, I believe. One question is for video depositions, can we use Zoom only? Are additional videographers required? And then the second part of that question is, can counsel stipulate to Zoom depositions without court reporter present, but transcribe the deposition later if needed?
I'm not going to touch either one of those. Those are crazy questions, man.
Yeah.
No, those are great questions. First of all, yes, you could do a videographer. I mean, that as long as social distancing is involved, and that is according to the code, your official transcript. The Zoom transcript or the Zoom video would not be anything. It wouldn't mean anything other than maybe to show unprofessional conduct in a future motion to compel. One of the things in the program handouts we gave is you might want to get a stipulation that all the requirements of the code are waived, and this is what you're agreeing to, all right? So if you agree that the Zoom deposition can be transcribed, then that works. But again, you'd have to have some mutuality of it because you're straying from the code. And again, I know there's judges that stray from codes, but you've got to look toward what a judge is going to do, and the judge, you have to presume, is going to follow the law. So if there's a side agreement, the judge will enforce that. So because the judge will be following the law. And I don't know if you'd run into court reporter issues about transcription of a Zoom video or not. That might be something to talk with your court reporter about. I have been learning recently in having refereed a number of depositions recently that a lot of these agencies are not allowing lawyers to stray from the code in terms of whatever you do at the end of the deposition and say, we'll leave the code and you have so many days. They're requiring code compliance. So that could be sort of an indication that you might run into some issues with that. Sydney, would you want to add anything to that? Put your mic on, Sydney.
No, I don't have anything to add to that.
Okay.
I do. I've got something to add to that. You
Okay.
you may think you're going to be saving money by not paying for a court reporter, but you're probably going to have to pay a paralegal or somebody to try to transcribe a deposition. Good luck with that. And not only that is can your paralegal do it professionally, where number one, it's admissible in court if you're trying to lodge it, as a transcript, an official transcript of the deposition. I think that it's a neat idea, but practically speaking, I wouldn't go there. Conversely, I think that the videos are very useful. And if you get a stipulation of the videos, that would be admissible, and you've got the transcript to go along with it. It's my opinion.
Well, if you don't have an oath in the deposition, you'd have to have some officer of the court giving an oath anyway when it starts. So you need that court reporter. Otherwise, it's not testimony. Remember the jury instruction? A deposition is the same testimony as if taken here in court. So you have to have an oath. So you can't get away without a court reporter now that I've really thought about it. All right.
Nicole, our next question.
So to tap off of that, someone asked, is the use of an impartial observer like a videographer or other professional neutral person being present to ensure that, for example, a potential witness or influential person who is not a party is not present? Or is a court reporter still used? Also, someone said that in a recent Zoom deposition, the court reporter asked them to all participants to back up their cameras and keep hands visible so that no one could coach by chatting privately or text messaging. Is this realistic?
Wow.
I know lots of them.
I'll answer that. It's not realistic. Unless you got Judge House in the room saying, hey, behave yourself, because we talked about this before. What do you do if you're doing a deposition via Zoom and somebody's acting wrong? They refuse to take off the sunglasses, or they're doing something. Well, obviously Judge House has got some words about that, but controlling people's hands and giving the power to the reporter rather than a judge, I think is not what we do, right, Judge House?
Yeah, no, I mean, I think the court reporter meant well, but I'm not sure about her ability to enforce it, or his ability. I'm sorry, that was a little, his or her ability to enforce it. If you need to take a contentious deposition via Zoom, then you need to really think about it, and then maybe build in protections, or do something that, for example, if it's not going well, stop it, get an ex parte application into the court. I think they are still ruling on those, and request a referee, and then go from there, just like you would normally. And the video of it is probably the best evidence of the need for the referee. All right. And you can even put on the record, I think I see you looking at your phone, Mr. Deponent. Ms. Deponent, are you giving looks to your lawyer to get some advice? You can put all that on the record. It can all be done. And that's done in depositions that are taken in a normal scenario. Oh, we did have a question, it turned up, saying, why can't a attorney give an oath, or as an officer of the court? The problem is the neutrality of it. You need to have a neutral person give the oath. I know it's in the code somewhere, I just don't have it on the tip of my tongue. All right.
Sydney, this is a question for you. An attorney wants to know how he responds to objections from opposing counsel who argue Zoom is not secure. And are there any other alternatives that you would suggest he proposes?
I think there are a lot of different platforms that are available. There's a WebEx, there is the even Google has a platform. There's a lot of different platforms that are available. The difference is that Zoom has its breakout rooms, and I'm not sure that anybody else really has these breakout rooms that you can, for mediation purposes anyway, to go in and out of the rooms. With respect to, what was the question again? Make sure I understand it.
Unmute myself. So basically, they're asking if opposing counsel objects to using Zoom because it is not secure. What can their argument be to that, or if there's another platform?
Yeah, and all of these platforms have different levels of security, and so you can talk about each one of them having different techniques. One, for the Zoom platform, I put as a default having a waiting room. And a waiting room is probably the most important security, because as the host, you can see who is waiting before you let them into the meeting. So that one, nobody can get into the meeting until you've affirmatively brought them into the meeting. They can't just jump into the meeting. All these Zoom bombing situations where, because Zoom used to have 9-digit code for every meeting, and people randomly would try to find a 9-digit, and they didn't have that waiting room feature on. And so as soon as they hit the 9 digits, they came right into the meeting and they could wreak havoc. Secondly, when you are in the meeting, you can lock the meeting. In other words, nobody else can enter the meeting once everybody's in the meeting. One of the problems with a locked meeting is that you have to be very careful, because if somebody drops out because of transmission, you have to make sure that you can bring them back in and that you're aware that they're out there waiting. And that's why I give my cell phone number, to make sure that they can call me to let me know that they've dropped out and that they're trying to get back in. Because sometimes there is an image that's left when they've dropped out, that you think that they're just having a transmission problem or something like that, that they're still in the meeting, but they're actually dropped out and they're trying to get back in. The third thing that is available is that there is a way in which you can require, first of all, a password for everybody, and a password restricts who can get into the meeting. But there's also a requirement that the people authenticate. In other words, that they get the Zoom app and they register their email and phone number and things like that. And so only people that are registered can come into the meeting. That's another way of restricting. And then there's encryption of the system. And Zoom's encryption apparently is a little different than others and all like. And I think that the only concern about encryption is really that it then requires you to have a little faster internet speed for everybody. And sometimes when people are at the borderline regarding internet speed, you don't want to have too many restrictions that are unnecessary, because as a practical matter, if you're having a deposition or a mediation, unless you're doing something at a high security level and on an international problem, nobody's going to want to get into your deposition or mediation. So, it's a balance. You're weighing it.
And I'm going to sound like a broken record, but isn't that all something you could put in a stipulation to assure counsel that there are sufficient security measures?
Yeah.
You're nodding your head. Yeah.
Yeah. And so, that's one of the things that, to me, the waiting room is the most important. So,
Okay. All right.
Sydney, I have one more question for you and then one for you, Judge House. It looks like we're getting close to the end of time, but.
I think, wait a minute, Nicole, Don and I talked about this ahead of time. If there's still questions, we can keep going.
Okay, perfect.
Yeah.
So, oops, I'm sorry, I hit mute on accident. Sydney, 2 questions for you. The first one is, have you experienced Zoom fatigue? And if so, how do you address it? And then the other one, we had some questions about the whiteboard. I answered them just with a typed answer because we can't demonstrate it on the webinar format, but it is part of the share screen in a meeting. Go ahead, Sydney.
I think the fatigue is a real issue. I think seeing yourself on these screens, one, it makes you very conscious of the image that you're conveying to other people, and I think it makes you very self-conscious, I think, first of all. And I think being on the screen constantly is fatiguing, because we don't feel that we're on stage constantly when we're in a meeting. We're there at the meeting, but we're kind of dozing in and out of the meeting and thinking about other things and things like that. And we don't feel that people are focused on us all the time. And so I think that the way to address that is really to recognize that it is fatiguing, and to take a lot of breaks, and to go. The breakout rooms are great because once you leave the breakout room, everybody can go get a bite to eat, go do something, and you're in another breakout room, and then you go back and forth and things like that. But I think it means that you have to make the sessions as short as possible, and session not in the overall session, but rather the meetings that you have, that you go in and out, in and out, in and out, because that keeps people's attention, and it doesn't fatigue everybody too much.
I actually I agree with that, but I also think we watch television hours on end and don't get fatigued by it. So this might be a psychological difference. I don't know. We'll see. I Zoomed with some friends last night, and they said, "This is my 4th Zoom meeting. I'm tired. I'm hanging up." So
yeah, but I think the difference in watching television is that it's passive. Nobody's watching you.
That's true. That's true.
You're only watching the screen, and it's a one-way kind of an activity. The problem with this is that it's a two-way activity constantly. So you're on stage constantly, and that's what's fatiguing.
As a judge, I'm really used to that, which is why we have an hour and a half for lunch every day. Okay. All right.
Heard about that.
Okay, Judge House, this is a couple questions came in regarding civil cases with trial dates set from like June to December of this year. If you know, what will likely happen to those trials, and if delayed for how many months? Have you heard anything?
Well, I heard through the grapevine, and again, this is just grapevine, that I think the court plans to start opening up June 22nd or in the middle of June, sometime around there. But again, like I said at the beginning, they're going to give priority to those cases that the law have priority for, which are criminal, unlawful detainers, and juveniles already working on a WebEx format to have hearings. And any CCP preference 36, the persons who are over a certain age, and you'll have to look those up. There's some very odd other conditions. So I think that those will be the most accommodated matters. And then whatever room is left over, which probably means a fair amount of continuances. But again, each judge will handle it differently. Within his or her own format, or their own calendaring matters. But I think you should take this as what's the future is going to bring, and that is there's going to be delays. I just can't see any way around it. Having managed a calendar for 22 years, you take 3 months off, you're going to have delays. And again, I really am a little concerned about the perceived spike. This happened with the Spanish flu, where everything settled down, and then the second spike actually killed more people 100 years ago than the first round of it. So I can tell you right now, from my own perspective, we're going to see the courts being cautious and the government being cautious about everything that could open up jurors in particular. I mean, let's talk about jurors. Are you going to force a juror to come in when there's a risk of them getting a disease they could die from, or take home to their families members who were weak and who could die from it? I don't think you're going to have the best jurors, the ones that do decide to come. So those are all things to think about in terms of your trial strategy. But again, you can still prep. There's nothing stopping you from sending interrogatories. You can do depositions by interrogatory if you want to. You can get requests for document production. You may, again, stipulate that the 45 days to bring a motion to compel can be extended based upon the lockdown orders or the safer at home orders. But those are all things to think about.
You forgot to mention private judging.
Well, okay, yeah. I mean, we're available to do trials. Absolutely.
I have a feeling that you're going to be very busy over the next 6 months. So.
Well, no, you already ruined it for me, Don. You said I make people stick to the evidence code. Come on, which I do. And any transcript that gets trial transcript that gets approved by a court as a final judgment would require the evidence code be followed anyway. So maybe I have an insurance policy for those.
Judge House, this question is directed towards you. It says, a critical part of a successful mediation is the physical exhaustion and commitment from being personally present that leads to breaking through to the parties and the benefit of final resolution. How can you get that same commitment through the remote participation?
I don't know that that's a problem, other than, you know, Zoom fatigue or in-person fatigue. I think it's the same thing. So you know, I actually get concerned when mediations go till 2 or 3 in the morning, because at that point, how effective are they if a resolution is seen? As a judge, I remember there were a number of petitions to confirm a settlement in probate, and one of the big issues was, oh my God, this went till 2 in the morning. I would have signed anything, you know, sort of like a, you know, I felt beat up and this and that. Well, you know, so I don't, you know, that's a two-edged sword. Particularly the fact that Zoom is such a, or this different technology does allow for a second session, and that's maybe effective because you're not traveling long distances. So, and I would also, I think we're going to see, and I think Sydney had this. You said you had, you did a mediation the other day where you had parties in the Netherlands, England, and you know, across the world. So you start a mediation at 6 o'clock in the morning, you get everybody within a relatively great time zone. So again, those are all factors you take into consideration. From my perspective, I find that the probate, and I suspect it's for family law as well, are very emotional mediations. I'm lucky if I can get an offer and a demand by 1 o'clock when we started at 10. And because everybody has to tell me their story. Everybody wants to feel like they've been heard, and I want to give them that. If you're dealing with a personal injury case or a business dispute, you're talking raw numbers from like 30 minutes in. So that's kind of my thought on it. Sydney, do you have anything to add to that? Unlock your mute.
Yeah, I think the Zoom technology does allow us to bring people together in a way that is easier than logistically possible. So, for example, you know, sometimes we need somebody. In fact, one of our mediators at ARC, John Raleigh, was talking about how you needed to bring in the head claim person or something like that in a particular settlement. And instead of what we normally do, which is either send a message through the person that is present and getting a response from that person that is present, or calling the person up on the phone and talking to that head person, we can actually bring him on screen. And he might be, you know, in New York, he might be in Europe, might be, you know, other side of the world someplace. And as long as they have an internet connection, they can be brought into the meeting, and they might be needed for 5 minutes, but that 5 minutes is not that difficult to accomplish, because the logistics of it is relatively simple. You just have the internet connection, and you push the URL, and you're in the meeting. And so I think that ability to talk face to face with somebody makes all the difference in the world, because it allows you to try to read what that person is thinking through their face, and allow them to see what you're feeling through your face. And I think that anger and the emotions that often come about in these mediations, I think are helpful in terms of getting it out, and not just to the mediator, but I think that it is important to connect opposite parties together, because I think that that's where the identity and trust starts developing, when people can see and empathize with somebody else. One fast story. Jerry Buss won 10 championships as the owner of the Lakers. And one of the things that I was really surprised by when he died at his funeral is that his business partner talked about how Jerry Buss does deals. And he said the way that Jerry Buss does deals is that he looks at the deal from everybody's perspective. And only if it is good for everybody does he go forward with the deal. And the business partner talked about how one time he did a deal, didn't think it was fair to somebody, so he threw in a couple of extra players to make it fair and then went forward with the deal. The 10 championships is not an accident. You know, the 10 championships were because people trusted him and I could identify with him because they didn't feel like they had to protect their pocketbook because he was going to take their money or take their assets, you know, if they don't watch out for them. They weren't defensive about themselves. They were willing to be open with him because he was trying to see and identify with the positions of the other people. And that's really the essence of how we reach agreements, is that we come to that point where we can have a modicum of trust that allows us to say, okay, I will agree. I will sign on the dotted line. And we do that in 98% of the cases, you know, and even in the 2% that we try, it's an agreement with the judge or it's agreement with the jury. And so it's our human nature, our social nature to try to identify with people and try to find that commonality that will allow us to agree and move forward.
And let me follow up on that. When I do my mediations, I talk to people and I say, all right, how many of you have been in a relationship for 2 or 3 years and then finally realized, oh my gosh, they lie, they're not trustworthy, they're narcissistic? I said, you know, the judge only sees a witness on the stand for an hour, maybe 2 hours, 3 hours. So this is the perspective of the other side, and it could win because of that very limiting nature of the jury trial or the court trial. And all of a sudden that sort of gets people thinking, wow, I could lose because, gee, you know, it could take, I won't be able to convince the judge how this person is really horrible and did what they did. So, you know, when it comes down to a credibility contest, like you say, Sydney, convincing people of the worthiness of the arguments of the other side is a really effective tool to settling a case, because you then give them a risk analysis. Do you want to risk them not seeing through to how horrible that other person is? I mean, it took you 4 years to figure out you should divorce that first husband, you know, that kind of thing. So you're much more humanitarian about it, Sydney. I always think, is it going to go to trial and what's going to happen? And I, you know, I think that's critical. And you can get that through a Zoom mediation. You don't need to be face to face to start telling people the strengths and weaknesses of their cases.
Judge House, I've got something to insert here. I've been in your courtroom before, and I've seen how you handle people that don't wait till the other person finishes the question and they talk over each other. One thing that Zoom does, it kind of keeps people in line, right? Because you can't talk at the same time. Otherwise, the court reporter is definitely not going to hear anything. So going along with the Zoom etiquette, as you described it, I mean, that's one of the benefits here. So anyways, Nicole, you got another question? Maybe we could wrap it up.
I do. I have a comment and a question. Judge Ochoa, who is on ARC's panel, said there's emergency rule 11, which if anyone wants to look that up, it is for depositions through remote electronic means. So I just wanted everyone to have that information. The last thing I wanted to mention is, Sydney, if you could go over, do you think it's necessary, I've gotten this question quite a few times, for people to purchase professional lighting or, you know, what temperature? Everyone's asking all about your technical aspect of how to look on camera. So.
How about a set director to kind of...
No, I don't think, I think that you just got to experiment a little bit with it. I don't think that it's really necessary to have professional lighting or anything like that. Although there's a lot of, you know, sets that are out there that are relatively inexpensive now that you can buy, and one of the real tricks of lighting is to not have direct lighting. And that is rather than having a spotlight on you because it creates shadows and the like, is to bounce the light off the ceiling or bounce the light off of a wall or something like that. But basically bouncing the light has, it kind of smooths the light out. Or putting a sheet in front of a window allows, the images from the outside not to be projected and creates a cleaner light. But I don't think you need professional lighting or anything like that. The cameras on the laptops now are so good. Like I was pointing out earlier, I was trying to create a dark image on my face, and I found that it was hard to do because the camera kept adjusting and focusing on my face and correctly adjusting the light for my face as opposed to my background and things like that. So the cameras are so good now that it's hard to take a bad picture.
And I just added a virtual background that Zoom has. So that's Golden Gate Bridge, I think, in San Francisco. And also, Nicole, could you show the lighting you have to our audience?
Sure.
Okay.
It is a clip. I'm gonna keep the light on, but this is on Amazon. You can clip it on anywhere near. It actually has a place for your phone. That's what I originally had it for, was Zoom calls for another purpose. But it's about $30. Our office manager at ARC, she got one that clips directly onto your computer, and I think she got it on Groupon for about $12. So they're very simple and easy to find. They're actually not sold out, surprisingly.
Very good. Well, I think we're coming to the end here. Judge House, Sydney, thank you very much for joining us. Nicole, you were great. And is there any way that we could send anybody, people that are interested, maybe a video that we recorded this? I think this was recorded. Am I correct, Nicole? Yeah, so all you have to do is email, not me, Nicole. And Nicole, maybe you could give them an email address if you're interested in getting this presentation, the tape of this presentation.
Yes, I believe Judge House put on the bottom of the outline today the email address for ARC to request the video recorded. I've already actually gotten some requests for that as well. So,
and I would also like to add that our case managers are available to do test runs with you, to do any kind of training on it. If you look at the ARC notice, it'll have who the case manager is, right? Correct, Nicole? And so, like, for example, I'm setting up a pre-mediation conference tomorrow or Friday, and Marjorie is going to be doing the tech for me, and that will test out how effective the lawyers are and what their technology is like. Like, for example, I've had to upgrade my bandwidth. We've had to get a new router. We've had to do all kinds of things, and I'm still experimenting with the lighting and the background. So those are all things that ARC can make available to you, and we're thrilled to do it because it's going to keep the judicial legal system going. So whatever we can do to help, we're there for you.
Oh, great. So on behalf of the Pasadena Bar Association, we want to thank you, Judge House, for doing this in Sydney, and we really hope that you can contribute even more. This was a fantastic Zoominar, and we look forward to more. And thank you to all of our members and all of our guests for joining us today. The meeting is adjourned.